Hi everyone, welcome to another episode of youbethejudge.com.au YouTube channel. This episode I highlight the serious flaws in the legal system when it comes to an apprehended bias and a judge in the Supreme Court of New South Wales having to recuse themselves. Effectively, if a lay observer would apprehend bias, that judge is legally bound to recuse himself. One of the flaws within that law is that the actual judge you allege has been biased conducts the hearing and makes the judgment on that assessment. To put that in context, that would be like a rapist who's been guilty of raping somebody being judge of his own case when he plainly committed the criminal act. However, he finds it was consensual and the matter is dismissed. I recently had an application for Justice Desmond Fagan to recuse himself from my proceedings on alleged apprehended bias as a minimum. During hearings, Justice Fagan has refused my legal right to make oral submissions. He's refused my requests and right to put on written submissions to complete my evidence. He's ignored evidence. He's made judgments without reading my evidence. During the 4 hearings I have endured under Justice Fagan, on multiple occasions he has called 4 security guards to come up, attend and escort me out of the building because I was trying to make submissions, and Justice Fagan didn't like those submissions. In my view, his conduct absolutely constitutes bullying, intimidation and harassment when I'm simply trying to present my case in a fair and equitable manner in my legal rights. Most recently, an independent neuropsychologist has prepared a report, 1, affirming absolutely Justice Fagan's conduct in my proceedings go well beyond an apprehended bias, and secondly, has opinioned that Justice Fagan's conduct in the proceedings has caused him to be a major trigger to my existing PTSD because of the conduct and nature of the hearings he conducted. I'm now forced into the Court of Appeal. Generally with an appeal, you may have 5 to 15 grounds of appeal. My current grounds of appeal, drafted before the court, include 90 grounds of appeal where I allege he has made error in law or in fact and or been completely biased in his conduct. In my respectful yet firm opinion, I say Justice Fagan's conduct in my matter alone equals apprehended bias, actual bias, breach of judicial oath, corrupt conduct, and in my view, there's no other alternative but for Justice Fagan to be removed from the bench immediately. I also allege, in my opinion, Justice Fagan has been guilty of aiding and abetting a strategy which led to me taking steps in 2020-22 under the case management of Justice Beach Jones to commit suicide. Justice Fagan has sat down a main hearing for a few weeks' time, making it impossible for me to complete the pre-trial documents to prepare for a fair and equitable main hearing. The Supreme Court of New South Wales have options open to them to intervene and make sure that hearing does not proceed because it will be totally unjust, illegal, in my view, if that hearing occurs under Justice Fagan. The Court of Appeal also have options and powers to intervene to make sure that hearing before Justice Fagan does not proceed because it would be completely unjust for that to occur. Stay tuned for more updates, including the 90 grounds of appeal before the Court of Appeal, and let's see how the justice system truly operates in this case.